So when we talk about the Wisconsin workers' compensation system or laws, what is that made up of? Well, in the state of Wisconsin, the bedrock of it, the foundation of it, is found in State Statute Chapter 102. The entire chapter is only for workers' comp, and it creates all the things that we're going to talk about going forward here, and it also gives an enabling power to the Department of Workforce Development, which is a government agency under the executive branch, to promulgate rules and make sure the law is being properly enforced. And so we have Chapter 102 of the statutes, and then the Department of Workforce Development Work Comp Division has enacted other rules, agency rules, and those are listed in something called DWD 80 and DWD 81. That stands for Department of Workforce Development 80 and 81. One is rules of practice that has to do with hearings and some other issues of practice within the industry. And also 81 is treatment guidelines, things that they've established for certain types of medical treatment for certain types of injuries and parameters for that. The law is also comprised of a bunch of decisions by something called LIRC, which is the Labor and Industry Review Commission, which is an appeals board that oversees what the agency does. And so they have a bunch of decisions that have essentially the force of law. And then there's a whole bunch of Wisconsin Court of Appeals cases and Wisconsin Supreme Court cases that have interpreted the law and put their stamp on it. So there's a whole series of things we have to look at to determine what the law is, the primary one being Chapter 102. So what is a compensable claim? And this is a very, very general, simplified way of describing it. First of all, there must be an employer and an employee who are subject to the Workers' Compensation Act. Second thing, the employee has to be acting in the course and scope of their employment and not deviating from the course and scope of their employment. And the third thing is the employee has to sustain an injury arising out of that employment that is not self-inflicted. Now, most of the time these are all pretty obvious things. Most people, most companies, they have to buy workers' comp. They're big enough that they need to have to have it. And most of the time, the employee is acting within the course and scope of their employment. And most injuries are pretty obvious where, let's say you drop something on your foot and injure it, or you have an amputation by having your hand in a machine, or you're driving on behalf of your employer and you get rear-ended and injured as a result of that. So most of them are pretty much clear cut, but there's a bunch in there that actually it's a little harder to determine. And we'll talk about that a little bit as we go forward. Once these three things are established, the employee's exclusive remedy against the employer are the benefits that are allowed under the Workers' Compensation Act. So the first thing we need to look at before we get into those benefits are who are the employers and the employees who are subject to the Act. Well, the first one is usually, if you're an employer who usually employs 3 or more full or part-time employees, then you must have insurance immediately. And the term usually was just defined in a court case actually last year, I think. Yeah, 2017, where the term, what does usually mean? Because it's not defined in the statute. So this was an uninsured employer who hired a third guy. And of course, the third guy got hurt. And the uninsured compensation fund paid the damages and then went after the 2 guys that owned the company. And the argument was about, well, what does usually mean? And the courts basically came down and said, and it seems pretty obvious, basically more often than not. So 50.1%, if that's how often you got 3 people, that's usually. And in that particular case, the court said, well, they don't usually have 3 people. Therefore, they don't have to have workers' compensation insurance. The second employer that's subject to the Act is if you employ 1 or more full or part-time employees who you pay combined gross wages of $500 or more in any calendar quarter for work done in 1 or more Wisconsin locations. So if you pay somebody gross wages of $500 or more in any calendar quarter in Wisconsin for work done in Wisconsin, then you must have insurance by the 10th day in the next calendar quarter. Hopefully that makes sense. So if in one calendar quarter you have those three things occur, then you have to have insurance in the second calendar quarter or in the next calendar quarter. And finally, I don't want to spend too much time on this. Farmers who employ 6 or more workers on the same day for at least 20 days during the calendar year, then after that 20th day, they have to have workers' comp insurance 10 days after the 20th day. And farmers have a whole bunch of special rules. Relatives of the farmer, some of them don't count. So there's special rules with farmers. Put that up there because that's just one of the employers who are subject to the Act. Employers not subject to the Act. Well, first of all, Federal Employees Compensation Act. So basically federal government workers. They have entirely their own system. They are not subject to the Wisconsin workers' comp law. Railroad workers. Makes sense. That's actually more of a federal law because obviously railroad workers are typically very often going across state lines. It's a whole different kind of an exposure. They have a set of laws that pertain only to them. Most of the time, most Wisconsin employers wouldn't run into that too much. The one that they can run into, and they have to be very careful of, is the Longshore and Harbor Workers Compensation Act. Similar to railroad workers, you've got a whole bunch of people that work in the at ports, harbors, terminals, wharfs, etc., loading and unloading areas, and essentially on or adjacent to the navigable waters of the U.S. That's an important term because navigable waters of the U.S. is under federal jurisdiction. And so as a result, we have the Longshore and Harbor Workers Compensation Act. Most of the time, not a big deal for most companies. However, if you send some construction people down or a welder down to work on a ship or on the docks or on a pier at a harbor, you may be running into this particular act, and you may have to make sure your insurance covers it or that you pay for it. You may have to pay a premium. It may just simply, if it's minor, you may just have to have it added to the policy. Just be wary of it if you're working in something like that. Always check it out. Always ask a few questions. So let's talk about employees. Most employees that we traditionally think of as employees who are subject to the Act. However, there are some that are excluded. First one, domestic servants and private home health care providers. So basically, if you've got a butler or a maid that lives there, you hire them directly. You're not hiring them from some agency. It's a contractual relationship between you and your servant, or if you have a private home health care providers. These aren't too common, obviously. They're out there, but most people don't have private home health care workers. It's usually through some kind of an agency or some other company. Another one is any person whose employment is not in the trade, business, profession, or occupation of the employer. This is really, I think, more to do with subcontractors who are working for you. It's meant that the subcontractors and work comp should really apply, not yours. That's essentially what that means. Sole proprietors are not subject to the Act. However, they may elect to purchase workers' compensation if they want. Same thing with partners in a partnership. They are not subject to the Act, but they may elect to do so. Same thing with members of limited liability companies. They also may elect to do so, but they don't have to. And again, some farm employees, which are certain relatives of the farmers, are also not subject to the Act. A few more categories of employees not subject. Qualified and certified members of certain religious sects. For example, in Wisconsin, you primarily see this as Amish or Mennonite, and they can work for you. That's not the problem, but they kind of hold themselves outside of our legal system. And if they're going to come and work for you, you have to go through a qualification process. Has to be signed off by an elder of this particular religious sect. They have to say that they're going to take care of the particular worker. There's some paperwork that has to be filed out and presented to the Department of Workforce Development for certification before that particular individual can come and work for you. So there's a whole process to it. Volunteers of nonprofits who receiving salary or in-kind compensation not totaling more than $10 a week. So if you're a volunteer of a nonprofit, then you are not subject to the Act unless you are receiving some salary or compensation less than $10, which isn't much of a threshold at all. Employees of Native American travel enterprises, including casinos. unless the tribe elects to waive their sovereign immunity and voluntarily become subject to the act. Recognized Wisconsin tribes are sovereign nations. They do not have to comply with our laws unless they choose to. They have to have their own financial responsibility for it, but they don't have to unless they voluntarily want to do it. Wisconsin has 11 recognized tribes right now. And really quickly, real estate brokers, agents, and salesperson. Don't want to get into that, but there's a couple of elements that have to apply in those particular situations. That statute is where you look to find that out and dig a little bit more. And independent contractors. I'm going to talk about that more at the end because that kind of deserves its own discussion. This comes up a lot as to what an independent contractor is and is not. And I want to go into that a little bit more detail. I want to hit that at the end, however, because I want to keep talking about the benefits and everything else.